A New York jury delivered a split verdict regarding actor Jonathan Majors. He was convicted on 2 of the 4 counts he was facing. The jury found Majors guilty of third-degree assault, recklessly causing physical injury, and a second-degree harassment, but acquitted him on the second-degree aggravated harassment and an additional third-degree assault charge with intent to cause physical harm. Reporter Lauren Victoria Burt was in the courtroom when the verdict was read. She joins us right now. So, Lauren, first off, so many people still are surprised that this even went to a trial. These were not felony charges. They were misdemeanor charges, correct?
Right. They were misdemeanor charges. I dare say I would really love to see some statistics on whether Robert Morgenthau or Cyrus Vance, the 2 previous district attorneys in Manhattan, have brought this type of misdemeanor case involving assault to a trial. This was, of course, brought by the office of Alvin Bragg, who's the current DA in Manhattan.
So one of the charges, the jury determined that he did not intend to, it wasn't intentional for him to assault her. So explain these, again, this sort of the split verdict.
It's really sort of, I think, a little bit difficult to understand. The inside the courtroom logic and body language would tell you that the jury seemed sort of intent on giving him something. There were 4 counts. I do think certain jurors were sort of intent in giving him something because we've been sitting here for 11, 12 days in court. There was one particular juror, a white male, sort of Clark Kent type with glasses and a comb over, who was the loudest to say yes when the jury was polled after they read the verdict, after the forewoman read the verdict. And understand that the makeup of the jury, it's a 6-person jury with 2 alternates and only 1 black person of that 8-person group, a black woman, I would say in her 50s. She was probably the quietest to say yes when polled by the clerk in the court. As to whether or not she agreed with the verdict. She sort of quietly said yes. And so I thought that was sort of interesting. But I do think there was a sort of pressure there maybe to do something, give him something, and not just let him off on all counts.
This was the statement from the DA's office. At the Manhattan DA's office, we are committed to centering survivors in all of our work. The evidence presented throughout this trial illustrated a cycle of psychological and emotional abuse and escalating patterns of coercion far too common across the many intimate partner violence cases we see each and every day. Today, a jury determined that pattern of abuse and coercion culminated with Mr. Majors assaulting and harassing his girlfriend. We thank the jury for its service and the survivor for bravely telling her story despite having to relive her trauma on the stand. Manhattan DA Alvin Bragg. Now, here's what's interesting. You look at that statement there, Lauren. They talk about this pattern. During the trial, they introduced previous text messages from Jonathan Majors to her. They also, I believe, had a previous a person testify. But the other thing is that the NYPD felt there was enough there to arrest her, and they did. And they charged Grace Jabari. But the prosecution chose not to prosecute. And I talked to one attorney who said there's no doubt that if he got convicted, she would have got convicted for assaulting him.
Correct. Yeah, so she was actually arrested. That was, of course, downplayed. I do think that part of what Alvin Bragg's office is doing is, regardless of what the evidence is, women apparently can never be wrong in any situation. So it didn't matter that Jonathan Majors is on film running away from this person. It didn't matter that we had testimony from a driver, the only person witnessing them in the car, a driver not hired by Jonathan Majors or Miss Jabari, by the way, testifying that she did everything and he did nothing. Didn't matter that we had video of course, as you're showing right now, Jonathan Majors running through Manhattan away from this person. And apparently it didn't matter that Miss Jabari was out clubbing at Lucy's nightclub at 145 Bowery Street the same night that all this happened, and then returns to Mr. Majors' residence and locks him out. Didn't matter that he called the cops in fear that she might commit suicide. None of that matters, apparently. There's no evidence that matters. doesn't also matter, I guess, to Alvin Bragg, that there was no pattern of anything. There was no pattern of abuse testified to in this case. So I have no idea what he's talking about in his statement about some pattern of abuse. I think that Alvin Bragg's office is on a political mission that has nothing to do with the actual evidence presented in this case, and actually another case which you highlighted on your show earlier in an exclusive interview. So this would, I think, represent some sort of a change in policy in the Manhattan DA's office that we did not see under Cyrus Vance or Robert Morgenthau. And that change in policy appears to be disconnected with actual evidence that is presented in court.
Atlanta attorney Jonquil Neal joins us right now as well. She's worked as a prosecutor, also defense attorney. Glad to have you here. As you look at this, explain this, if you will, this split verdict that comes from this jury. But first, I'll start with: have you seen where, again, a misdemeanor charges would go to an 11-day trial? Is that unusual?
Yes, I would say, and good evening, everyone. Thanks for having me. I would say that, yes, that is unusual for a misdemeanor trial to last that long. And frankly, it's unusual for this kind of case to proceed to trial, right? Because normally in a case like this, you would potentially have some reduced pleas, some pleas to a reduced charge or reduced sentencing involved. And so a case of this nature, you would normally not see. However, it appears that Mr. Majors wanted to clear his name. And it appears that he thought that, and his attorney thought that this would give him the opportunity, but the jury came to a different conclusion. But what I will say as it relates to your initial question about this split jury, essentially the first charge, right, the third degree assault with intent to cause physical harm, in a lot of criminal cases, for specific charges is what we call is mens rea, right? And so that means that the person has to have the intent required to commit the crime. And so they found him not guilty of not having the intent to have caused her physical harm. They found him at a lower level, which is a reckless, a third degree reckless charge, where essentially his behavior was a conscious disregard and substantial and unjustifiable risk of physical harm to her. And that's essentially what they found. So they didn't find him as low as negligence. They didn't find him as high as he intentionally harmed her, but they found in the middle for reckless.
When you look at that video, the video of him placing her in the car, but she fighting to get back out, follows him, he pulls himself away, and then he's running away from her. What do you make of that if you're talking to a jury? Because the defense says, here's somebody who was trying to get away from her. Later, he's the one who calls 911 when he discovers her in the apartment in the middle of the floor.
This is a very, very challenging case. It's a challenging case for the state. Domestic violence cases are very, very challenging to bring, and they're very, very challenging to defend. That evidence of what we saw in the video of him running away from her shows that essentially really hurts the state's case, right? They could have acquitted him completely off of that video alone, right? Because we see him de-escalating, right? We see him actually running away from her, trying to get away from her. And so we see her become the aggressor, although she alleges that he initially was the aggressor. And so I think that the evidence can go either way, right? Because as it relates to what the district attorney put in his statement, is that there's this cycle of abuse, right? And these relationships, these inter-partner domestic violence cases generally happen in closed doors. You generally don't have this kind of evidence. But it looks like evidence of an innocent man running. That's what the video looks like. So, and it looks like she's the aggressor. And it gives the appearance that we're looking more at like a Johnny Depp type of case, right? Versus a pattern or cycle of abuse at the hands of Mr. Majors.
What about which could explain split verdict, where they felt that he was culpable in some way and other ways wasn't guilty? What still is weird to me is that the NYPD felt there was enough there to charge her, but the prosecution was hell-bent and said, absolutely not, we're not going to prosecute her, and then she's their star witness.
You're absolutely right. And frankly, the big question is, right, is this case brought forward in the nature of what it is because of who Jonathan Majors is, right? It's because of his celebrity, because of his status. I mean, that has a lot to do with it, because if you're talking about this kind of case with these kind of facts, generally speaking, a prosecution office might just dismiss and not move forward on either case, right? Because the evidence conflicts to such a high level. So does it have a lot to do with who Jonathan Majors is? Yes, it does. So, that's just the fact of the matter of it. And so they had the choice to not pursue either of them due to the conflict of this evidence. However, they decided not to move forward against her and to move forward against him.
This obviously has already resulted in what we anticipated, losses for Jonathan Majors. Shortly after this became public, Lauren, Disney, Marvel Studios dropped him from one of their franchises. Did his attorneys say if they're going to appeal?
They haven't. In their statement, there was a line in there about how he plans to clear his name, which sort of sounded like to me that they would try to appeal or take some action. And it wouldn't surprise me if they did, because there were several things about the way the case was presented that I think are appealable. The judge would not allow a police detective who had processed Jabari's arrest to speak very much. All of his testimony was effectively objected to. The judge would not allow the jury to hear the body cam audio, so you could see the video but not the audio. Nobody could figure out why that was the case. And I think the jury was frankly unaware of some things that, they should have been aware of and probably will be made aware of when they see, on TV tonight. But during the trial, as presented, was not aware of. So I do think that there is likely to be an appeal.
And that, again, that really what stands out to me there, John Coyle, just the fact that, I mean, you look at even the judge here. I mean, you have cops who say, we believe this woman assaulted him. DA goes, we're not going to prosecute. And the judge doesn't even allow that to come into play?
Right. And as it relates, the trial isn't televised. So as it relates to the specific reasons why, or what evidentiary reasons why the judge didn't allow the specific audio to play is unclear at this juncture. It could be a multitude of different reasons as to why that audio was not allowed to be played. I would want to know more intricately about what were the arguments on both sides for why. Certainly in cases and trials that I prosecuted, there have been instances where the body cam footage had to be muted and could not be played. So it'd be interesting to know what those specific issues were. And I'm not sure. I know that you were you in the courtroom when they were disputing that issue about the body cam footage?
Yes.
And its admissibility? Okay.
Yes. And the jury, I think the judge, the days that I was in there, which was 3 days, I got the sense that anything that would shed a negative light on Ms. Jabari was blocked the entire time. I mean, effectively. But there was some, this case, even though it wasn't televised, which I think it should have been, quite frankly, there was a lot there, evidence in terms of cameras, text messages, that you could figure out where these two people were almost every minute the night that this happened. And that should have been enough. And apparently it was not. And this video of John Majors running through Manhattan away from Grace Jabari is theater of the absurd. I mean, I think we all realize that if this was flipped around and Mr. Majors was running after Mr. Bari, we would have a completely different view of this. He would be seen as the aggressor. But somehow this office, Alvin Bragg's office, thought that somehow or another this complete de-escalation didn't matter. And I guess these jurors thought that it didn't matter. But it is, to me, absurd to look at this and think that he somehow was the aggressor. And then he decides that same night to spend the night in a hotel up on the Upper East Side of Manhattan on 77th Street, which was way away from where she was. So that was another point of de-escalation. So as I say, when you look at the evidence of this case, this is a very surprising result, to say the least.
Junquel, final comment.
Mm-hmm. Well, what I will say is, this specific case is a very difficult one because you have the different issues that are going on in this case, right? You have the cycle of violence that happens in interpersonal relationships, the things that happen behind closed doors that none of us are able to see. But however, this case makes it different because we've got all this evidence that shows him running away and him de-escalating this situation. And it makes it very troubling that the jury came to this conclusion. However, that is one of the risks of taking cases to trial. I mean, you have your constitutional right to a trial, but it's very risky to do so. And so it's a verdict where the jury has taken their time to deliberate on the evidence. And it definitely is interesting in the least to say that a case like this would have made it to a trial with both of them having been charged.
All right, then. All right, Ms. Newton-Neal, I appreciate it. Lauren, thanks a bunch as well.